right, everyone, I'm going to go ahead and get started. Welcome to Oliva Gibbs Energy Education Series. My name is Emily Sheffield, and today I'm going to be presenting on common title issues encountered when operating on federal lands. So again, my name is Emily Sheffield. I'm a senior attorney here at Oliva Gibbs, based in Houston. I focus on due diligence and title examination here at the firm. The firm in general does oil and gas matters, primarily title opinions. And I've been here at the firm for almost 5 years now. So today we're going to be talking about federal oil and gas leases. So those oil and gas leases covering federal lands. I want this presentation to be a general overview into federal leases, so I don't have any state-specific information in the presentation. So everything we talk about today can be generally applied across all states that have federal leasing. But just keep in mind that when dealing with different and specific state lands, you're going to be dealing with different Bureau of Land Management offices, depending on where your state lease is located. Also, we are only going to be talking about onshore federal leasing today and no offshore. And so we're going to start with recording and constructive notice, record title versus operating rights, right-of-way leasing, lease segregation, and then end with communitization versus unitization. So to start off with, we're going to start with recording requirements and how that plays into constructive notice. If you take away only one thing from today's presentation, it's going to be that when you are working with federal leases, you must search and file in both the county records and the federal records. For federal leases, it's a dual recording requirement for ownership instruments. And if you only record in either the county or the Bureau of Land Management, you're going to end up with an inaccurate view of what's going on with your lease. And you won't have adequate protection against bona fide purchasers. And we'll get into that a little bit more later. So starting with the federal recording requirements first, where are the instruments regarding the federal lease kept, and where are you required to file them? So the federal records are kept with the Bureau of Land Management. I'm going to be referring to it as the BLM. It's a section of the United States Department of the Interior in Washington, D.C. However, the BLM does have state offices that also maintain duplicate records for the leases, and the state offices usually have the most complete file for the lease. And I can tell you the majority of stuff that I examined does come from those state offices, because the common practice is to search the state office records only, although the BLM takes no responsibility for incomplete records that are kept in the state offices. Also, those records regarding operations such as well completions, production, unitization, and communitization, those are also maintained in those BLM field offices. Also, keep in mind that there's the legacy rehost system, LR2000, which is also available online. It provides a searchable database, but it does not include the documents themselves. So you want to make sure that you really utilize the services provided by a land services company, federal abstract company, to go through those BLM files that's been created for your specific lease. That way you make sure that you're getting all of the relevant documents. Instruments regarding your lease should also be filed with the county clerk. I'm sure all of you are familiar with the county clerk, very common with your fee lands. This is where the records for each county that the lease is located is kept. So you would search the county clerk's office in the county where the property is located, just like you would for an ordinary fee lease. Also, as with fee lands, don't forget to check all locations where the records are going to be kept, like the district clerk, probate, and tax records, if any of your portion happen to be patented fee lands. So why search and file in the federal records with the BLM? The simplest answer is because the federal regulations require you to. That is a statutory obligation. Each transfer of record title or of operating rights shall be filed with the proper BLM office on a current form approved by the director or an exact reproduction. And the rights of any such assignee shall not be recognized by the BLM until such assignment has been approved by an authorized officer. So the BLM is going to adjudicate your lease based only on what their records show. They do not take into account the county records. So if you have a gap in title in your federal lease file, the commissioner is going to reject that transfer. Here I've included a list of instruments that need to be recorded with the BLM as required by the statute. So assignments of record title, and we're going to get into what that means a little later. Transfers of operating rights, overriding royalty assignments, mass transfers, corporate name changes or mergers, probate materials, divorce decrees. So pretty much anything that has to do with transferring title into that lease, it's going to need to be filed with the BLM. So why search and file in the county records? So the purpose, the intent of recordation is to provide notice and to protect a party from a third party bona fide purchaser. And there is no federal statute providing that the BLM records, either in Washington or in the state offices, provide actual or constructive notice to persons acquiring interest in federal oil and gas leases. So that's a big deal, right? So although you are required to file with the BLM, those recordings do not provide notice. Notice can only be provided by recordings that are found in the county records. Also, I've seen time and time again where an assignment is maybe filed with the BLM on the approved form, but then when the assignment gets recorded with the county, there are additional add-ons, if you will. You know, maybe an override will pop up in the assignment that wasn't included on the form, or some other provisions like death severances. So it really is important to search and file with both the BLM and the county. And lastly, many instruments are not or cannot be recorded with the BLM, such as liens and easements. So examining federal titles and some common title defects, sometimes the dual recording can be a little bit overwhelming if it's your first time working with both systems. I'm going to go over and suggest kind of a three-step method for examining federal title that we use at the firm so that you can be sure that you've checked what and where you need to find the instruments regarding your lease. And then at the end, I'll hit a few of the major title defects that we see on a regular basis. That's something to watch out for. And then here's just kind of a picture of the master title plat and the historical index, which is what's going to be included in that lease file. So step one is the Plat Books or tract books, sometimes called the land status records. These are organized by township and range. They contain the actual plats, those historical indexes, conflict sheets that detail disputes between claimants, the master title plats, and the oil and gas plat. It's going to reveal surface patents, your right-of-way, leases, those kind of things. And then also make sure to look at the historical index and the serial registers for patents, survey plats, and any unpatented mining claims that might pop up. Also important for step two there is to determine the proper leasing act that your lease falls under. That's going to really set your parameters for what you're looking at with your lease. Most federal leases are going to come under the Mineral Leasing Act of 1920. It's been amended several times. It set up the basic system for leasing federal lands that we still use today. It's the same, it sets up the same concept as that we use for fee lands. In exchange for the opportunity to develop the land, the lessee is going to pay royalties and rentals to the United States, who acts as the lessor landowner. Since its inception, the Mineral Leasing Act has been amended numerous times. So when you're examining your lease, it's important to determine what time period we're working with here to kind of see which amendments of the Leasing Act are in play for you. And the Leasing Act provides for two types of federal leases: competitive leases and non-competitive leases. Competitive leases are those that have been auctioned off to the highest bidder within a known geologic structure, and then the non-competitive lease was offered but no bid was received, and usually is with an unknown geologic structure not producing. So those are the normal federal lands. And federal lands that constitute a right-of-way, that's going to have a very specific thing that we'll get into towards the middle of the presentation. And then lastly, tribal lands are going to fall under the Bureau of Indian Affairs, and that is going to be outside the scope of today's presentation. So if you have those lands, that's going to be a whole separate issue. So step 3 is to check the case file for your active leases. The case file is going to have the transfers of record title, and it should have all of the other assignments, that list of things that we talked about earlier. Those should all be found in the case file for the lease. And again, a case file is going to exist for every federal lease. And if your lease has been segregated, which we'll get into, there will be a separate case file for each newly created lease. So some common title defects here, I would say that the competing chain that's created by, or potentially created by, the dual recording requirement is the #1 issue that I see. Every opinion that I write ends up having a comment and requirement about recording instruments in both places. Due to assignments getting filed in one place and not the other, or assignments on a form maybe filed with the BLM that then conflicts with the assignment that's filed in the county, all of these things can create a parallel chain of ownership that conflicts. Also, sometimes there's an underlying issue that will become apparent when you're examining the title. Maybe some lessees don't file with the BLM to avoid lease segregation. It's also true that the forms are not very user-friendly. If you want to do some creative conveyancing, net profits, interest, and production payments, that stuff's not easily shoehorned onto the federal form. Also, depth severance issues are pretty common as far as conflicting with the county and the BLM records. Confusion there about where to include it on the form. So just things like that come up pretty frequently. We'll get into right-of-way more later, but also create some complexities. And then the excess royalty clause, which hasn't come up too often for me personally, but I've included it here. Statute there used to provide that an agreement creating overrides that, when added to previous overrides and the lease royalty, aggregates in excess of 17.5%. It's not allowed unless the agreement expressly provides that the excess royalty shall be suspended when the average production of oil and gas per well per day averaged less than 15 barrels on a monthly basis. This has been deleted in 1988, but may still apply between parties if it's provided for in an assignment. So again, just something to look out for if you're working with an older lease, because it does come up. So record title versus operating rights and how to transfer. So we've been talking about record title and operating rights. So what's the difference? The BLM has forms for both of these type of transfers, and I've included them here just so you can see them in case you're not familiar with them. It is very form-based. There are different columns for the percentages that you want to convey and retain, but again, the forms are pretty similar and mistakes happen in which form to use or where to put the information. Record title is not record title as kept in the county. Record title is a form of ownership that's unique to federal leasing. Some states use that lingo as well, but record title is the primary ownership of an interest in oil and gas that includes the obligation to pay rentals, the rights to assign and relinquish the lease. The record title owner is the person or entity that is going to account for the lease to the BLM. They are the one that's held responsible in the eyes of the BLM. Record title can't be transferred as to different depths. You can't break out record titles separately for oil and gas. And you also can't break it up into anything smaller than a 40-acre subdivision. BLM approval is required for a record title transfer, and this is where filing with the BLM is so important, because if there's a gap where someone didn't file an assignment of record title and then record title isn't showing in the assignor's name, then the commissioner is going to reject that transfer of record title. Operating rights. Operating rights can be considered the same or the equivalent to a working interest. It's the interest or the contractual obligation created out of the lease, which authorizes the holder to enter onto the lease lands to conduct drilling and related operations, exploring for oil and gas. For operating rights, you can limit as to certain horizons or zones. BLM approval is required for a transfer of operating rights as well. And then operating rights may or may not be transferred through an operating agreement. So something to keep in mind if your land is subject to an operating agreement. Assignments of record title. So again, you can convey record title by itself, you can convey operating rights by itself, or you can convey them both at the same time. Timing is important on this though. So operating rights are not severed. So when you start out, you have both. If they have not been severed, a record title assignment will convey both operating rights and the record title interest. So this happens a lot in what I've seen at the beginning of the lease. The first couple of assignments there, they'll do an assignment of record title, and the intent there is to convey both operating rights and record title. If that's the case, it's not necessary to file both a record title assignment as well as an operating rights transfer. You can just file the record title assignment. However, as time goes on, and if you have a severance from record title and operating rights, an operating rights transfer must be filed. So if you had 100% and then you assign part of it, you have severed record title and operating rights, you're going to need separate conveyances moving forward. Partial assignments of record title. Partial assignments created when an assignor conveys 100% of record title interest in a portion only of the lands in the lease. When that happens, the partial assignment is going to segregate the lease into two separate leases. The segregated portion of the lease creates a new lease, and it is assigned a new lease number. We're going to get into this a little more, but just know that this is what happens here. It releases and discharges the assignor from all obligations thereafter accruing with respect to the assigned lands. Operating rights transfers must identify the lease formation depths either by zone, formation, or deposit. Again, sometimes that is not what happens, but you should include that information. It is not necessary to file separate operating rights transfers when conveying interest in several sections. One transfer can convey various interests at various depths. But again, if that is the method that you choose to use, make sure that you are very specific. Overriding royalty assignments. Overriding royalty interest may be filed by the assignment of record title form, or you can use the transfer of operating rights, or just an assignment of your choosing. But again, you want to be very specific with this, because I often see conflicting instruments regarding overrides. Only one original executed copy is required. BLM approval is not required for the overriding royalty assignments. So you are required to record these with the BLM, but the BLM is not going to necessarily approve it. They will just accept the instrument and include it in the file. And then the overriding royalty rules are also going to apply to production payments. If you're going to have a large transfer of interests, mass transfers are an option. It's used when conveying interest of any type in a large number of federal leases to the same entity, generally 10 leases or more. Filing should be made on the BLM form with an attached exhibit of all of the leases involved. And each assignment must be adjudicated and approved individually. So take that into consideration for your timing purposes, because this can slow things down a little bit. You should also be recording entity name changes and mergers. For the BLM to recognize a name change or merger, you need to submit the following: a list of serial numbers of all leases, any pending assignments and unit and communitization agreements, a copy of the certificate of name change or merger from the Secretary of State, a copy of the amendment of the Articles of Incorporation or other instrument. And if one company buys out the interests of another company and it's not a merger or name change, you need to record assignments or transfer of operating rights. MLA qualification statements, basically the intent with these is to keep out foreign entities from buying up all of the federal leases there. So leases or interests may be acquired only by US citizens or stockholders in a corporation. Aliens can only own through corporate stock. Also, just something there, record title cannot be held by minors, but may be held by legal guardians or trustees of minors. Sometimes this comes up when it's a probate situation. We've seen this. And then there's an acreage limitation there. So now we're going to move into federal right-of-way leasing. Right-of-ways can cause some particular issues when dealing with federal leasing. We have the Right-of-Way Leasing Act of May the 1st, 1930. Certain federal rights-of-way can only be leased under the Right-of-Way Leasing Act if the right-of-way predates your lease. So again, you may not realize that your lease doesn't cover these prior existing rights-of-way. Also, the original right-of-way grantee may have a limited fee in those lands, subject to ownership reverting back to the United States. Also, sometimes the lease may specifically exclude right-of-ways. In 1983, the act was amended with the apparent intention to limit this 1930 act. So now the act appears to only apply to railroad right-of-ways as of March there, and then reservoir irrigation easements issued pursuant to the act. Also, this comes up on potential potash deposit lands. So again, with that, you're kind of looking towards these old leases as this has been updated. However, despite the broad language in the 1930 Act, the BLM only issues right-of-way leases for railroad and reservoir easements, but the language actually includes other rights-of-way acquired under any law of the United States, whether the same be a base fee or mere easement. So you're looking at maybe a conflict there. So again, something to be observant. Just know that it's a possibility. Make sure you read your lease and look at any dates regarding right-of-ways that have been created. So what does it all mean? Owner of the right-of-way has preferential right to lease or may assign the right to lease. Notice will be provided to adjacent landowners. Adjacent leases have a right to submit a bid for compensatory royalty in lieu of issuing a lease to the right-of-way. If the adjoining landowners submit compensatory royalty bid, the right-of-way lease or compensatory royalty agreement will be awarded to the offer most advantageous to the United States. Again, it's very technical and it doesn't come up too often, but it's something to be aware of. Because the BLM will not issue leases except as to the railroad and reservoir right-of-ways, so again, it comes up, are you technically unable to lease prior right-of-ways? There's a question there. So best practice is to obtain an assignment of preferential right to lease or make a bid for compensatory royalty agreement. However, note that a compensatory royalty agreement is not a lease and it cannot be assigned by assignments of record title or operating rights. So now we're going to move into talking about segregating the federal lease. I got into this a little bit already, but there are a couple of ways that your lease can get segregated into multiple leases. So what do I mean by segregated? Well, you have the original lease. Let's say it covers 640 acres. That lease can potentially get split into other leases of smaller acreage. So maybe 2 320-acre leases. The original lease would keep the original lease serial number, and the new lease would get a new lease serial number. This can happen by an assignment of record title if you assign 100% in a portion of the lands. So in the 640-acre example, if I own 100% of that 640-acre lease, but I then convey 100% of record title in 320 acres to someone else, that's going to segregate that lease. Another way for segregation to occur is by unitization. If only a portion of the federal lease is committed to a unit, the uncommitted portion is segregated into a separate lease. And then a note there, segregation does not occur when a portion of a committed federal lease is eliminated from a unit. If segregation by an assignment happens during the fixed term, the primary term, before production has been achieved, the segregated lease will continue for the remainder of the primary term or for 2 years thereafter, whichever is longer. If segregation by assignment happens during the extended term of the lease, primary term, second term, then when the lease is being held by production, if the lease was issued before September the 2nd of 1960, the segregated portion will get a fixed term of 2 years. If the lease was issued after September the 2nd of 1960, then the segregated portion will continue due to production on the lease. What about segregation by partial unitization that occurs within the fixed term of the lease? The general rule is that the lease will stand on its own. So the lease will be effective for 2 years or the remainder of the fixed term, whichever is longer. Production on non-unitized portion will not extend the unitized portion. Unit production will not extend non-unitized, non-producing portion. I know that's a lot to digest there. It just goes to show how complex some of this can get in different circumstances when you bring in the unitization and the segregation. Again, a last note there, the BLM is generally not going to approve unitization of a specific formation if that's going to result in horizontal segregation. Lastly, segregation by partial unitization within the extended term. So the segregated portion of the lease is extended as long as the base lease is producing. So that's going to be the exception to that general rule that we talked about earlier, that the base lease is going to stand on its own. In this specific case, the segregated portion will be extended as long as the base lease is producing. And lastly, for a base lease with non-unitized segregated portion, the base lease is going to continue for the life of the non-unitized segregated portion. And if unit production is obtained before cessation of production in that non-unitized portion, the unitized portion is going to continue for the life of the unit. So again, some technicalities here that you need to be aware of. And if you have any questions about the technicalities of your lease, definitely something that you want to follow up on. So lastly here, I'm going to get into unitization versus communitization. Some terminology to start off with here. Pooling is not exclusive to federal leases. You can have a federal lease that is pooled with fee lands, but pooling is not a term that's specific to federal leasing. Pooling is the combination of two or more leases into an area to meet minimum state spacing requirements. And when you talk pooling, the majority of the time you're going to be talking about fee leases. And the goal with pooling is that it prevents waste and protects correlative rights. Communitization, however, is a strictly federal lease term. Sometimes it's used for state leasing as well, but when you talk about communitization, that's going to be pooling for federal leases. Communitization is the correct term as opposed to pooling. Lastly, we have unitization there, which is the unified development and operation of an entire geologic prospect or a producing reservoir. So the purpose of unitization is conservation of resources in order to serve the public interest. The unit area operated as a single entity without regard to lease boundaries. Some advantages of unitization are cost, recovery, and common facilities to serve all wells. You can kind of share in the burdens there. For exploratory units, the BLM model onshore unit agreement for unproven areas. You have the allocation of production made on an acreage basis. And then exploratory units can be developed in stages, generally by participating area surrounding a producing well. That part of the unit area which is considered reasonably proven to be productive of unitized substances and paying quantities. There are two types of unit operating agreements. You have two form options there. Form 1 for undivided interests. The interests do not fluctuate as participating areas expand or contract. Or Form 2 for divided interests. Working interest owner's share in production is determined by its interest in defined participating areas. Now, with communitization, leases may be voluntarily pooled and a designation of pooling recorded in the county. However, when federal leases are involved, you must execute a a communitization agreement. You have allocation on an acreage basis, and the model form for federal communitization agreement is generally followed. For your communitization agreement, you want to make sure that you define the communitized area, any depths or formations, and any substances, oil or gas. It needs to be executed or ratified by each royalty owner, each working interest owner, or overriding royalty interest owner. It needs to also define how production is going to be allocated among the operators and mineral owners. They have a new streamlined approval process to help ensure that these agreements are approved within 120 days. Those timelines have kind of been, COVID determinative at this point, but the goal is 120 days. And I'm gonna kind of end with a comparison here. Unitization, operations, production, anywhere within the unit are considered operations and productions on each committed lease. Inclusion of only a portion of a lease in the unit affects the lease segregation. Segregated portion outside the unit extended for a remainder of fixed term of 2 years, whichever is longer. And then communitization or operations production, you have anywhere on the lands is considered production or operations on each tract. Inclusion of only a portion of the lease does not affect a lease segregation. If your communitization agreement terminates, your lease is going to continue for a fixed term or 2 years, whichever is longer. And that's all I have for today. I know that can be a lot of info there. If you have any questions, feel free to shoot me an email. I'd be happy to reply or have a phone conversation if necessary. And also, please take a look at our website there and sign up for any other webinars that you may be interested in. And I hope you enjoy the rest of your day.